Hi everyone. So today I have brought this new case to you which is concerning the music industry. So imagine you have been listening to a music label for a very long time, and now these music labels are ready to give licenses to an AI generated music company, or a company who is ready to provide its music to data sets to an AI company who holds AI models, and they are going to use that music from an established music company to train their AI models and come up with some kind of music which you've already heard before. But this music won't be the actual music which you've heard before, but there could be changes to this music which can be done, and but it's not going to sound exactly the same. There may be variations, but the underlying beats, the rhythm, the tone, and that's by and large going to be the same. So this case is basically premised upon this, where the American Federation of Music or the American Federation of Musicians has sued two major music labels. One is Universal Music Limited, and the second one is Warner Bros. Music Group. So American Federation of Musicians has sued Universal Music Group and Warner Bros. Music Group. So UMG and WMG for our references. So UMG and WMG have decided to hand over their rights to AI generated music, which is Suno and Udio. So this is also quite a recent case. So Suno and Udio basically produce AI generated music. So now this AI generated music typically is some kind of through a settlement benefit. UMG and WMG have started giving out licenses and have started a commercial investment with these two AI generated music companies or music groups, much to the grievance of American Federation of Musicians, because any kind of settlement should be directed to the American Federation of Music as opposed to UMG or WMG, but very conveniently most of the money is being directed to the UMG and WMG as opposed to the American Federation of Musicians. So this was the main claim or main point that they were contesting upon. So while the defendants in this particular case were defending their rights, and they were protecting their interests, and said that a significant source of revenue with regard to the retrospective settlements which they had made with the American Federation of Musicians, and the significant amount of revenue which they are receiving from the AI generators, who are basically willing to reach a settlement or a compromise. So that basically works very well for them, and that is the reason why they created their own instruments or their own sort of agreements with this AI generators, because they have created this music with a lot of talent, with a lot of creativity and hard work, and they are willing to exchange that hard work or give that hard work to the AI generated companies so that they don't fall short of any creativity or any talent, and they are willing to settle for any amount, or rather for a big amount, and this basically is credited directly to their revenue. And by such a huge settlement, they want to boost their company's revenue, and they find nothing wrong in doing so. So therefore there is a weak argument which has been posed by AFM, the American Federation of Musicians, through the complaint that they filed in federal court on Friday. So the AFM's lawsuit, which has been filed against UMG and WMG, comes very later, or it reached or the very fact that it reached settlements with Suno and Udio is basically it reached the settlement at a much later date, and AFM was not initially informed about it, but the settlement that they reached is one of the world's largest settlement. It was basically the first deal that was struck in sometime around October 2025. So the WMG came much later. So UMG first struck a settlement, and in October 2025, the WMG came later and struck a partnership with Udio in mid-November. But however, WMG became the first major label to strike a settlement with Suno. So the big three record companies were basically Sony Music Company, UMG and WMG, in which WMG was the first one to settle with Suno and Udio in 2024, acquiring the settlement from these AI generator of massive copyright infringement. So even though they fell into a place of copyright infringement, these AI generator companies, UMG and WMG were very keen on giving them permission to sort of adapt to their iconic songs and create something that is going to be beneficial or attractive to the public to listen to over a long period of time. However, AFM restrained from all of this and was not up for this kind of a settlement. So in settling with Suno and Udio, the AFM also alleged that UMG and WMG are allowing these AI companies to in a way steal their rights or steal their songs because they represented musicians to do exactly what they wanted them to do. So which is training their AI model. So the lookout of these music companies, AI generators like Suno, Udio or Sony Music Entertainment, they wanted to train their AI models on these data sets, music, a number of songs and a number of soundtracks and recordings, so that they could produce new recordings based on the previously existing recordings, and on ingestion of these kind of works, they could create their own set of work. So the AFM also further stated that such kind of settlements which are made, and also the compensation which has been directed towards the AI companies for the past violations which have been made to the copyright, substantial portions of the music have been taken by these AI companies to train their models, both on a retroactive as well as a prospective basis, and further revenue which will be generated by these AI companies will be passed on as revenue to UMG and WMG, leaving AFM with very few money or very less revenue in the future. So the defendants have in a way failed to share in settlement proceeds what they have accrued as revenue with AFM, which AFM feels is very unfair to them, because these record labels were actually a product of this AFM. So even if the music is copied, trained and incorporated into development of AI models, it is basically a commercial exploitation of the iconic music that actually already existed. So these bodies are basically now just commercially exploiting the music which is pre-existing and which people are acclimatized to over a long period of time, because it is well protected by certain artists, their talent and their creativity, which is completely ignored here at this particular stage. So the Warner Bros. Music Group is at its developmental stage, and it has a particular ecosystem of its own, a community of its own. But the argument which was raised by Warner Bros. Was that it wants to create a AI community as well, where they, on behalf of an artist, want to spread their music everywhere, and they also want to benefit from this kind of settlement. So they, in not only in monetary terms, but also beyond that in terms of creativity. So therefore, this kind of unproductive action which has been released by the AFM during their ongoing negotiations with Suno and Udio will only be a very regressive method or a restrictive method to prevent such labels from sharing and spreading the vocal voices which can be heard on a global platform. So the representative for UMG said that the company has been at the forefront of protecting its rights for a long period of time, but it has not allowed its artists and musicians to expand their rights during the developing age of AI. So therefore they felt that as a responsible musician or a music company, they owe some of their rights to AI, and therefore through such licensing agreements they are receiving compensation for the music, which is going to lead a very new generation ahead. It's going to take the generation forward tomorrow, and it is going to going to give a voice to artists who are going to be trained on these iconic classics and build a new rhythm for their own. So the AFM chose this route during the collective bargaining negotiations, and UMG and WMG will continue their work in this particular area and will try to build this area through negotiations. So the UMG representative as well as the AMG representative said that they expect this trend to move on in a particular direction. They expect to create a strong working relationship or a bond with these with some kind of mutual respect, or with AFM also through a mutual respect for talented musicians in the industry. So on one hand, they did not abandon AFM completely. They still have a deal. They still have an agreement with AFM where they want to strike a good bond, a very strong bond with AFM, and they want to develop and build a strong music industry. And at the same time, they are not against licensing or drawing a settlement with AI generators like Suno, Udio, or Sony Music Entertainment, where they are allowing them as AI generators to come up with new content. So on both the sides, if we see, they are trying to sort of draw a bridge between what are iconic classics and what are trending remixes created by AI generators, which we see today. So for this very same reason, this case became very pivotal in our understanding of the music industry. However, at the same time, while this is a hottest issue which is rising up for debate in today's day and age, it should also be very important for these AI generators to maintain certain regulatory protocols to safeguard their work. That is, they should be aware that the copyright belongs to someone else and they cannot exploit it to a large extent. So tomorrow they cannot claim a copyright over these particular songs and say that they are the initial stakeholders of that particular music. So to that extent, they have to give that sort of autonomy, and they have to give that credit to the original musicians who created these songs, and only that way can they proceed forward. So these are the clauses which should be very clearly phrased and written in these clauses and agreements which they are going to put out there. And secondly, while the likes of Suno and Udio are controversial in the business, so as songs have been used without the permission and AI slop songs sometimes continue to flood the streaming services, they are growing more and more popular as the days pass by, and counting on them being a significant investment is itself a huge thing for the AFM, UMG and WMG. It is the responsibility of these AI generators such as Suno and Udio to make this music, build a platform for itself and look at it as a business, and also look at the ethical aspects on which this AI is being trained, and it also has to ensure that a fair settlement deal has been closed with Suno and Udio, and that particular deal or a settlement, it should close around $400 million funding and around the value of the company, which is at $5.4 billion. So therefore, the settlement should be fair, the negotiations should be fair, and only on cutting such raw deals, the business will be allowed to go, not only of the AI generators, but also of those music labels or record labels who are basically at the receiving end of the money, and who have also given them the freedom and the rights to perform this kind of music, or to also borrow this kind of music and come up with their own creations in order to attract or appeal the new generation, and allow them to provide create their own space in the music industry. And at least for the sake of that permit which has been given to them, they should act more responsibly, and they should adhere to very fair settlements and negotiations. So this is headed in a very interesting direction, and I would like to explore the music industry even more, because it is far more complicated than what I have presented to you today. So let us research more in this area and let us discuss our research findings. Thank you.